I have one more question for you, but just a side note, just from a DIFC-related perspective on the issue of discrimination. One, you should remember that it was always there. It was always in the law. It's just that there was no penalty, which also left it open to interpretation by employment lawyers to sort of imply that into the employment contract and basically have an open-ended sort of canvas to bring a claim on. So the fact that we've actually now brought it into, there's a statutory remedy, also means that you know exactly what you can be docked for. So that there is a benefit there for employers, even though they may think that this is something that has been put in there purely for the sake of employees. I think secondly, just, DIFC, if you look at what we are trying to be as obviously an international financial center, which means we have to be in line with global best practice. And so it was definitely something that we had to look at, not just have the statement of thou shalt not discriminate, but to actually have a penalty for it as well. So from that perspective, it was important for us to put in. And I think it's also very fitting that this happens in the year of tolerance. Within the UAE, and if you look at the pillars set out by His Highness Sheikh Mohammed, in the context of tolerance, then the issue of discrimination and not to discriminate is one of the key issues. So that was an important one for us. Just finally, Gordon, just from a practical perspective, if we think now about family-friendly rights and discrimination, how will the changes affect DIFC employers, and what considerations should they bear in mind going forward?
And on that point, Jack, I think it's an important one. We've received a lot of requests from clients that have parent companies outside the jurisdiction, particularly on the back of the Me Too campaign and so forth, where they have a concern that they have a black spot in their business in certain geographical locations. So I think your point's a valid one, that in order the introduction of the discrimination remedies means that by hook or by crook, DIFC licensees need to ensure that their policies, their procedures, their practices are aligned with international best practice to avoid there being the adverse PR that is associated with discrimination claims. So I think that on that point it is a welcome one. In terms of what steps employers need to take, obviously Rebecca's mentioned the review of existing employment contracts, your template contracts going forward, your policies and procedures, particularly in light of the indirect discrimination claims that I mentioned, where you might have a policy which, unbeknownst to you, can potentially discriminate against one group of individuals rather than another. I think also, from an HR and legal perspective, where you're running not just a redundancy exercise, but any termination. Whereas in the past, you might have said, okay, we have a poor performer, and we know this individual's underperforming, we're going to terminate their employment. In the past, there was generally really little risk associated with that decision, provided you paid notice pay, provided you paid end of service gratuity. The difficulty you have now, which again, I say difficulty, it's making sure that your HR practices are robust, is that if that employee turns around and says, well, hold on, I have an appraisal rating which is 5 out of 5, I'm a black female, for example, and there's a white male over there who's got 1 out of 5, and we do the same job, and you've terminated me, but you've not for poor performance, but you've not terminated my colleague. I'm using that as a very extreme example, but it does demonstrate that more care is going to have to be taken from an HR perspective when managing terminations. And I mentioned redundancy, whereas in the past it might have been the case where a business would have said, we have to let 10 people go. Okay, let's decide who the 10 are, we know who they are, let's exit them. Now I think there should be more of a focus on more of a UK-style approach where you provide, you agree upon a selection criteria, you apply that selection criteria, and you can then objectively demonstrate why those 10 individuals have been exited as part of the redundancy exercise.
Thanks.
Can I just jump in, actually?
Sure.
Just on that point about to reflect the law reflecting, I suppose, the current times and the Me Too campaign that has been felt and addressed across the world. I think the fact that we now have clear language around discrimination and harassment is obviously very important for employees. But it is also important for employers to ensure that they do dust off their policies, and particularly equal opportunities, harassment. How does an employee raise a complaint or a grievance? Do you have a whistleblowing policy? These are all things that I think employers now have to think about, particularly grievances, which people haven't had to think about before. And the other thing I would add is, because an employer can also be vicariously liable, in other words, the employer is liable for the employee's actions. If you have an employee in your organisation who, for example, is harassing or discriminating against someone else, as the employer you could be liable, unless you've taken steps to ensure that you've tried to prevent that action. So again, one of the things that I think we're starting to see is clients think about training and ensuring that within the workplace everybody understands the level of behaviour that is expected across the organisation.
Thanks. So that brings us on to Ben, last but not least. Ben, your heading is termination, settlement agreements and gratuity. So from that perspective, my first question to you is, does the new law affect an employer's ability to dismiss an employee?
Yes. I think the first thing to make clear is the new law does not introduce a regime of unfair dismissal. There was a lot of discussion during the consultation process as to whether that was something that needed to be introduced for various public policy reasons, and primarily to ensure that the DIFC maintains its reputation as a good place to do business. It was felt that actually that wasn't needed to be introduced here. So there is no still no concept of unfair dismissal in the DIFC. So what that means is, broadly speaking, provided you don't discriminate against an individual, the rules in terms of termination are broadly the same, but there are a couple of key differences. So under the existing law, there are minimum notice periods. They are 7 days if you have less than a month's employment, 30 days if you have less than 5 years employment, and then 3 months if you have more than 5 years employment. But actually those notice periods, or those minimum notice periods, were largely made redundant by the fact that there was also the express ability in the existing law to agree notice periods which are actually lower than or less than those minimum notice periods. So what the effect of that was, and what we saw with a lot of employees, or employers rather, was that they were taking advantage of the ability to agree extremely short notice periods with employees to enable them to get them out of the business quickly in the event that they wanted to terminate their employment. Alternatively, an employer was paying in lieu of an employee's notice period, so that effectively bringing the end of their employment immediately. Now, we looked at it and thought, well, what can we do short of introducing a regime of unfair dismissal to try and afford employees better protection? And we've done that in two ways. Firstly, we've expressly removed the ability of employers to agree notice periods which are less than the statutory minimum. So from the 28th of August, every employee will be entitled to the minimum notice period set out in Section 62 of the new law, regardless of what your employment contract says. And secondly, we remove the ability of employers to unilaterally pay in lieu of notice. So the effect of these two changes is that in the unfortunate event of an employee being dismissed, they will always have absolute certainty as to how long or when exactly their employment will come to an end. And of course, given that visas are linked to employment here, that's a huge change and should provide a much more comfort for employees.
Thanks. Just to be clear, can an employee still be dismissed for cause?
Yes, so and there was a lot of discussion around this as well. Actually, the dismissal for cause rule still remains the same. And the reason that has not been changed is actually over the course of the past 5 years or so, the DIFC courts have looked at the test for dismissal for cause and have actually established what is very clear guidance in terms of why an employer or an employee actually can dismiss for cause. So yes, the ability to dismiss for cause still remains, but there is one caveat to that, which I think you'll come on to in terms of gratuity.
Yes. We all know what the question is for now. But the one key thing that gave us a lot of food for thought, and people are still discussing this also in the context of the savings scheme that's coming, is that under the current regime, when somebody was dismissed for cause, an employer could actually make the decision unilaterally to forfeit that person's gratuity payment. Can you just explain to us how that will work under the new regime?
Yes, so this is a huge change, and this is something which definitely polarized opinion during the course of the consultation, and everyone will have their own views. But from the 28th of August, any employee who is dismissed for cause will still be entitled to receive their end of service gratuity. Now, many employers have and will look at that and think that that's outrageous. Why should an employee still be entitled to receive their end of service gratuity in circumstances where the employer believes that they have done something seriously wrong? And the rationale is very simple. And we did look at other jurisdictions on this point. And personally, I couldn't find another jurisdiction whereby if an employee is dismissed for cause or gross misconduct, as it's also called in a number of other jurisdictions, they lose all their pension entitlement which they've accrued during their pension. And obviously the gratuity, until the new system comes into place, obviously the gratuity is an equivalent of pension. So yes, it may be frustrating for an employer to have to pay out gratuity to an employee who may have done something wrong, but equally, I think it was felt that an employee shouldn't lose what could be a significant sum accrued over 15 years or so just because of one unacceptable piece of conduct at the end of their employment. So that's the rationale. Everyone will have a view. I didn't make the decision.
Yeah, I mean, we obviously ultimately made the decision from a policy-related perspective. And I think the one key thing that one needs to remember is because there's no process or the notion of fairness or unfairness, unfair dismissal, it means that when an employer makes a decision to somebody that they've been dismissed for cause and hence they should forfeit their gratuity, is it basically placed the onus or the burden on the employee at that point, basically without money, to go to the courts and say, I was, this wasn't proper cause, and the courts have pronounced on what are the reasons to be dismissed for cause. And then once he basically got over that, or she got over that barrier, could then say, please pay me my end of service benefits. What we are doing now is we're saying, instead of putting the onus on the employee, which it was pretty much could be an arbitrary process leading to that, because there's no notion of fairness. Okay, so and fairness typically is substantive and procedural fairness. So if you take that out of the equation and you leave it purely in the hands of the employer to make that decision, and then putting the onus on the employee to go to court to disprove that, is slightly imbalanced from a fairness and an equity perspective. But by doing the way that we've done it now, we're not saying that we've taken away remedies of employers. If an employer, say, had a fraudulent employee that stole from them, there's nothing precluding the employer to go to court immediately and get injunctive relief and say, I'm about to pay this guy his end of service benefit. he owes me a lot of money. It's clear from the criminal proceedings going on. As a consequence, I want this amount to be attached. So it's not as if we've taken away the remedies of employers. I think we've just tried to make it a little bit fairer, given that there's no general concept of fairness in dismissal.
Yeah,
So I think people should understand that.
Yeah, I think the one of the ways of looking at gratuity is actually it's not really a reward for good performance. So therefore, why should you be able to withhold it in the event that an employee does something wrong? It is essentially a retirement benefit. It's not a bonus.
Okay. Moving on, and I'm sure we're going to come back to that one as well. The current law had this issue that there was no mention of people that could actually waive their rights and as a consequence enter into settlement agreements. And that created a lot of uncertainty as a consequence between employers and employees when they signed settlement agreements. Can you explain to us what has been done in the new law to try and alleviate that uncertainty?
Yeah, so the existing law actually went further than not referencing this. It expressly states that an employee could not waive their rights under the existing law. So what this meant was employees and employers would commonly, and still do, enter into settlement agreements with their employer. But actually, our advice, as I'm sure a few of you have heard from us, will be legally, and under the current law, those settlement agreements are not binding in respect of the waiver of statutory rights. They are in relation to contractual rights, but not in relation to statutory rights due under the employment law, because the employment law says you cannot waive those rights. So this was obviously a problem. Both employers and employees needed certainty on this. So the new law flips that on its head and says actually an employee can agree to waive their rights under the DIFC employment, under the new law, in two circumstances only. One is to resolve a dispute, and the other is to agree the termination of their employment. Now, the reason the mechanism has been limited to these two circumstances is what we wanted to avoid, and what we've seen in other jurisdictions, is employers and employees agreeing settlement agreements, for example, on the first day of employment, so as to remove the employee's ability or entitlement to receive holiday. That is entirely not the point of the settlement agreement. The settlement agreements are primarily aimed at resolving a dispute or dealing with issues on termination. Now, importantly, the settlement agreement must be in writing. So there's going to be no arguments, oh, he promised me this, she promised me that. It must be in writing, and it will only be binding if it contains a warranty to the effect that the employee has been given an opportunity to receive independent legal advice from a DIFC registered lawyer, or the parties have undertaken mediation proceedings with the DIFC courts prior to entering into that agreement. Now, there was, this was again another area of discussion as to whether there should be a requirement for the individual to warrant that they have taken advice, and actually that was felt to go slightly too far, and whilst that would have been great for employment lawyers, actually the position is not quite so employee or lawyer focused, and just says that the employee must have had an opportunity to take legal advice.
But just from a legal certainty perspective, if you were an employer and you had to prove that somebody actually had the opportunity to take legal advice, then as an employer, you may actually want to go further and say, you know, here's an X amount of money, you know, to actually go and take advice.
Yeah.
That's how you can get absolute certainty.
Yeah, absolutely. I mean, I think our advice to clients will be, look, if you want to eradicate the risk of any arguments over this opportunity to take advice, actually what you'll be saying to them is, or what you could say to them is adopt for example, the UK position and say, look, you have the right, or rather, we need to give you the opportunity to take advice. In order to do so, we will contribute a set amount to your legal fees. And that will remove any uncertainty, but you don't have to do that.
And purely from a practical perspective, not having settlement agreements signed on the day of the termination would probably be a practice to adopt, because otherwise how can you be given reasonable opportunity to seek legal advice when you're having an agreement put under your nose on the day of the termination of your employment? Yeah.
Okay, and finally, Ben, we know there's other changes coming in relation to end of service gratuity, which is obviously not the topic of today's discussion, just keep that in mind. But obviously some changes have been made in terms of end of service, Ben, as it stands. Can you just maybe take us through that and provide a few highlights?
Yeah, so I mean, broadly speaking, the actual calculation of end of service gratuity doesn't change. What is I guess the two key points are, as we've already said, gratuity will always be payable. I guess that's the first takeaway. And the second point is that basic salary for the purposes of calculating gratuity must be no less than 50% of the employee's total remuneration. And the reason for that change is very simple. We came across a lot of employers who would try and circumvent or reduce their exposure to end of service gratuity by agreeing with an employee that actually their basic salary will only make up 30% of their total remuneration. So now that's not going to work. It must be at least 50%. The other change that's been made, not so much a change, just more of a clarification, is that employees will have an opportunity or can elect in writing to receive contributions to a pension fund or retirement fund or substantially similar savings scheme. That scheme doesn't have to be in the UAE, it can be outside the UAE. But importantly, any contributions made to that fund by the employer must be no less than the gratuity the employee would have been entitled to receive had they been receiving gratuity, not participating in that pension fund. And that particular change was to address the concern that actually an employee could again very much reduce their exposure on termination by setting up a scheme or using an offshore scheme and putting in the employment contracts, which, let's face it, rightly or wrongly, a lot of employees don't read particularly closely. They could put a clause which says, we will contribute 1% of your salary in lieu of your end of service gratuity. So it's to avoid employers taking advantage in that way. So the aggregate contributions will need to be the same as the total amount of gratuity they would have received. And that's contributions. It's not the value of the pension fund pots, because obviously the employer cannot control that.
Okay, that brings to an end sort of the formal set of questions and answers, just to sort of highlight the key issues and maybe give a little bit of background towards that. We would now like to open the floor, and just because I had my back to these guys all the time.
Good morning. If we have an employee who resigned and we agreed with him not to serve the 3-month notice period, and we agreed to pay him the 3 months notice period, what is the effective date of his termination? Will it be the resignation date, or will it be the last day of the 3 months notice period? And the second question, when do we expect to receive more information in relation to the DIFC employee workplace savings trust? Thank you.
Who's going to take the first one? I'll take the second one.
Shall I say the first one, just because it covers what I spoke about? So if you pay an employee in lieu of their notice period, their employment effectively comes to an end immediately, because of course you're paying in lieu of, instead of the notice period, you're giving them the money. But your question actually flags one thing which I didn't mention, So I said that under the new law, employers will not be able to unilaterally pay in lieu of notice. But actually, it also expressly says that employees will be able to agree to receive a payment in lieu of notice in a settlement agreement. So it doesn't remove that flexibility.
And the effective date being the final date. It's not the date that they leave the office.
So yeah, it will be the date of the resignation if you are. It depends sort of what has been agreed in terms of the notice period, but it will be the date of the resignation, because by paying in lieu of notice, the employee is not serving their notice period.
As regards the second question, just to give you a little bit of an update, and let's try and keep it at that. The RFP process, in terms of the appointment of the services providers, meaning the master trustee and the scheme administrator, the final date for submissions is actually today, which means by the end of next week, we will have a short list of 3 for each of those appointments. We will then spend pretty much, I think, up to the 21st of July, going back and forth, taking additional presentations to come to a decision towards the end of July. Once those appointments have been made, I think one of the first things that will happen from a scheme administrator perspective is outreach, massive outreach to the DIFC in terms of one-on-one with employers, in terms of having a website, having a call center, everything that you can imagine for an exercise which involves potentially 2,000 employers and 24,000 employees. You can, an exercise to do that form of outreach and education will then start with that being driven by the administrator. So that will take up a lot of the second half of this year. In terms of the details of the scheme, I think that's been well publicized, and a lot of questions are in relation to what will be a qualifying alternative. We will probably by the end of August publish for public consultation changes to the employment law. Just when it comes, when it becomes effective, we will publish proposed amendments, but that's just for the sake of dues. And one of the key components of that would be the regulations to the employment law that will put down the details of what be a qualifying alternative scheme. Thanks.
Morning. So this with regards to Article 62, minimum notice period for unlimited term contract. It says that the employer has the right to terminate by providing the minimum notice period without cost. Does it mean that an employer have all the right to terminate without any reason, without cost, by providing minimum notice period?
Well, provided it's not for a discriminatory reason, yes. It goes back to what Gordon was saying. There is no legal obligation to provide a reason for termination if you're terminating on notice. However, of course, if you don't give a reason for termination, it begs the question, why was the individual terminated? And then it opens up an argument that it was for a discriminatory reason, which all employers will want to avoid. So our advice to clients will be, look, you should have a very clear rationale. It doesn't have to be fair, but you have to have a very clear rationale which is not discriminatory for terminating that individual's employment on notice under Article 62.
But as Ben mentioned earlier, there is no right for an employee to claim unfair dismissal. So that isn't in the old law and it's not in the new law. So the fairness of the dismissal is not relevant.
Thanks for the opportunity. I have a question in relation to the new law and the new sick leave periods, which you explained, Jacques, that full pay will be applied to the first 10 days, so I think 50% for the next 20, and then no pay for the next 30. When and that has to do with the implementation or the effective date of the law. So when do you expect that the period actually starts for the first time? Will this be with the publication of the law now in April, or will it be the first time applied in 3 months down?
Happy to take this one, given it fell in my segment. I mean, the law is effective from the 28th of August, so there's a new statutory minimum entitlement from the 28th of August, so that is the effective date. Where you might find there are issues to resolve from an employer side is your existing employment contracts may not state that your employee's entitlement is with reference to the DIFC employment law. It may state you're entitled to 60 working days leave, in which case that is a contractual entitlement in the contract to that amount of leave, and therefore that's something that is going to have to be managed within your businesses in terms of how you reconcile that with the new statutory minimum entitlement that will be effective from 28th of August. From a perspective of planning how the implementation, you would essentially have a prorated entitlement until under the old law until the 27th of August, and then you would have your minimum entitlement from the 28th of August thereafter.
That's why you have a panel. They get to answer the tough questions. Okay, so any more questions? There's one at the back there.
Actually, just while we wait, can I just add on the sick leave point? As Gordon mentioned, it is the minimum entitlement. So, of course, there is nothing to stop an employer offering more. And, of course, as Gordon says, it's likely, if you've got it in your contract at the moment, that you're going to be offering more than the minimum anyway. I think also, of course, it will be market-driven. So I suspect a lot of our clients may actually continue to offer more than that minimum entitlement under the employment law anyway.
So just from the same question, what would the rolling period be then? So would we look at from 2018 last year, or is just going forward?
So it goes back 12 months.
In terms of, it goes back 12 months, yeah. So essentially, whenever you would have that sickness entitlement for each 12 months of your employment running on a rolling basis, unless your policies and procedures provide for a prorated entitlement for the first portion of the year, and then say a cut-off date from 1st of January so that everybody from an HR perspective has that entitlement running from 1st of January. If you don't do that, then the entitlement would be for each individual on a rolling 12-month basis, dependent upon when the commencement date of their employment was.
So for this particular law, would we look at 2018 then for the rolling period?
Well, it would depend. So essentially, let's say you had aligned everybody's sick leave entitlement so that it began on the 1st of January of each year. Then the individual, and let's say you only applied the minimum amount under the law. So as Rebecca said, you didn't apply an uplift from your employment perspective, from your internal perspective. It was just the statutory minimum entitlement. And let's say everyone started from the 1st of January of each year, because you'd aligned that within your workforce, then it would be a prorated entitlement from 1st of Jan to 27th of August in respect of the old law, and from 28th of August to 31st of December in respect of the new law.
Thank you.
Also, just as a follow-on note, I think the one other thing that we will do before this law goes live on the 28th of August is to have a separate workshop on some of the more practical issues, such as that one.
Hello, so I have two questions. The first one is about the warranties for the opportunity to receive legal advice that we discussed for settlements. Does that apply to settlements in general, or only in the case where an employee is waiving one of their statutory rights?
Only in that case where they're waiving statutory rights. Yeah.
And my second question is about the changes to the penalty clause, and specifically, so we said that commission, bonus, and those types of additional payments aren't going to be included in the penalty clause, but for industries or jobs that are sort of very commission focused, are there any remedies available for employees in those circumstances?
So the penalty really is looking at the normal payments that an employee receives. So the idea is if you've got these one-off or as I said, long-term incentive payments, that you're trying to take those out of the penalty award simply because it's not something which the employee regularly receives. However, I suppose if an employer says, well, actually, I'm going to say that all remuneration is now an additional payment and therefore is excluded from the calculation of what should be due within 14 days and thus is excluded from any penalty award, I think the court would actually look at what actually happens in practice. So I think you wouldn't just be able to say, oh, well, actually everything is an additional payment and I'm going to get out of the penalty. You would actually look at what the facts are and what actually someone regularly receives. So in the case of where someone does receive what is described as commission, but essentially is their regular salary, then I think you would be able to argue it's not actually an additional payment at all. But again, that's going to be very fact-specific on a case-by-case basis.
Thank you.
And just on that point, what it's intended to do is to prevent a situation where you have a deferred bonus scheme, or say the bonus year is from January to December and the bonus is paid in March of the following year and the employment is terminated in January and the company hasn't yet been able to reconcile its accounts and work out what the bonus to be paid in March looks like, that you're not going to have employees saying, well, look, under the law, I'm entitled to receive all of my monies that are due to me within 14 days of the termination date. Yeah.
And just to add to it as well, so the additional payments, yes, they can consist of bonuses, commission, etc. But in order to fall outside the requirements pay within 14 days, you do need to expressly agree with the employee that they will be deferred. So that's under Article 18.2. So it's not going to be a case of saying on termination, oh, no, I think that X, Y, Z is an additional payment, therefore you're not getting it. You will have to put the wording in your employment contract to say this bonus will be considered an additional payment for the purposes of DIFC employment law and will not be payable within 14 days. So that you have to deal with it in the documentation. You can't just wait for termination and then argue retrospectively.